Today is Friday, September the 13th, and we are talking to Justice Frank Williams, and he's being interviewed primarily by Dr. Aaron Crawford of the Center for Judicial History.
Thank you for being here today, Justice Williams. I guess the first question I have is if you could explain, how you received an appointment to the Military Commission Review Panel and later the Court of Military Commission Review.
It's I think a bit interesting because when 9/11 occurred, I was already the Chief Justice of the Rhode Island Supreme Court, but as with many of our fellow citizens, was quite disturbed with the terrorist attacks, and I had long before been concerned about terrorist cells and that something like this would happen because of our openness and our lack of vigilance and our trustworthiness as a nation. We trust many other people or each other, and we're many times disappointed in placing that trust. So 9/11 occurs. At the moment in time, I was mentoring the new law clerks that were coming into the court, and I gave it a great deal of thought, as many did. And it just so happened that I was very good friends, I still am, with the then commanding general of the Rhode Island National Guard. And as it turned out, when detentions were made, arrests of suspected terrorists, aliens, non-U.S. citizens were made, they were housed, of course, at Guantanamo Bay, which had been a very active naval base, much reduced in size and force. And the first security guard sent there was the Rhode Island National Guard Military Police Brigade. And after they had set up, the National Guard General, Centracchio, put together a group of other military and civilians to go down to visit them at Camp Delta at Guantanamo Bay. So I was one of them, and glad I did. And we went down in a C-130. We had to avoid Cuban airspace, landed at Guantanamo, ferried over, met with the brigade and the commanding general there, visited Camp Delta housing these detainees, which was pretty much in a rudimentary stage. The $1 billion in improvements and prison facilities and courtroom and military tribunal facilities would come later. So after my return, I read in the New York Times that they were going to begin military tribunals with these detainees. And I wrote to the Pentagon, to the Department of Defense, offering my service as, in some capacity, even as a judge. I was already judging and had been for some time. I didn't know anybody in the Bush administration or Secretary Rumsfeld or Jim Haynes, who was the general counsel for the Department of Defense, and lo and behold, I received a call from one of the counsel at the Pentagon and indicated that, yes, they would want me to consider being one of the civilian judges to hear appeals from those tribunals, military tribunals, scheduled or to be scheduled at Guantanamo. And that's how it happened. And I was invited down. I interviewed with General Hemingway, who was a retired Air Force general recalled to assist in this Office of Special Prosecution. And that's met Jim Haynes, the general counsel, and that's how this began. I was one of 5 civilian judges. One other was Griffin Bell, the former Attorney General under President Carter. He was going to be the chief judge, who I would later replace when he died of cancer in the second remuneration of the court there.
What were some of the issues that you encountered on the Military Commission Review Panel? Exactly, for instance, in the first in the first incarnation, what were some of the things that you were considering? I know that you didn't yet have a commission to review at that point. So could you explain a little bit about how it worked?
Well, it was a work in progress, wasn't it? Because this was new. These terrorists or alleged terrorists were not prisoners of war, as that term is usually understood under the Geneva Conventions in the 1940s, because they belonged to really no nation or country. They did not wear uniforms. They did not follow the law and rules of war, and they targeted civilians, including women and children. So the administration found itself in a very difficult situation and was challenged by what rules would be followed. And the criticism would come from other lawyers and courts on what President Bush's administration promulgated as rules and regulations. So we needed to address those. There were some rules that had been promulgated through the Department of Justice and also the Department of Defense. So we were bound by those, but we needed our own internal rules process, and we worked on them and issued them as our rules to begin with. Then we started to get, as you would expect, what we call interlocutory appeals. Not appeals from a tribunal themselves, because we've had very few that have gone through to judgment and sentencing, but there were always other issues that would come up before the trial itself or during the trial. So that's what we essentially addressed. And we would sit in panels of three, usually one civilian judge with two military judges. These were 06s, colonels or captains in the Navy, colonels in the other forces, a crew that they were all from JAG, all from their legal departments in the various services. A very impressive group. They had been around a long time, both as counsel, prosecutors, and now military judges to hear cases involving members of the armed forces. They were assigned to add to this contingent to consider appeals from Guantanamo.
Where would you usually meet?
We met by arrangements in between the Department of Defense and the federal judiciary in Washington, and we would use the courtroom at the federal courthouse in Lafayette Square, where the Circuit Court of Appeals, the U.S. Circuit Court of Appeals, would meet.
And how often would you usually meet? Was it something?
Well, that's hard to say. We had several meetings, many administrative meetings, and we had quarters across the river in Crystal City, where we did have for a while our headquarters for our group of staff and judges. So, but when hearings were held, it would be at the U.S. Court of Appeals.
Okay. Now, I know that part of the reason that you were interested in this issue was your historical work, of course, on the Civil War and the tribunals that were held during the war. So how did your experience as a historian influence your work on the court?
Well, I think that there were two driving, if not three driving forces. First of all, I wanted to offer my services yet again to our government. I had served almost 5 years in the U.S. military, even before going to law school, 3 years in Germany and a year in Vietnam. And I thought I could do this work as well as continue my service as Chief Justice of the Rhode Island Supreme Court. Secondly, I had been a judge, so I thought that my judicial experience, as well as my legal experience and military experience, would assist me in performing the duties of this court. And you're right about the Lincoln story, because I had been familiar with the use of military tribunals during the Civil War. There There were about 4,300 military trials of civilians, U.S. citizens, as well as some 60,000 courts-martials. So this was not a new phenomenon. Military tribunals had been around for a couple of hundred years. And despite the controversy that ensued, I believed in the use of military tribunals in cases such as what we were confronting, even though it was sui generis, really one of a kind, because it didn't fall into any clear paradigm that had already been regulated, like Geneva, except for humane treatment and our own Uniform Code of Military Justice.
Weren't some of the criticisms, though, that Guantanamo and the commissions themselves were violations of the Geneva Conventions or the Uniform?
Yes, Aaron. Yes, many criticisms were levied against the administration and the use of military tribunals and the rules that were promulgated by the administration, even from the military, even from the JAG branches of the armed forces. The issue here is that there is a law of war that many Americans don't understand, and even our allies are unaware of. That's been evolved over the centuries. And if you look at the Lincoln administration in 1863, there was the Lieber Code, General Orders 100, which was really the first codified rules of warfare, the law of war. And it was so acceptable that we not only used it during our Civil War, but it was the foundation for the later international conventions like the Hague Conventions that would take part of the Lieber Code or adopt it as the basis for an evolving code on the law of war. So this was not new. Maybe the administration couldn't make great arguments for its acceptability, but I believed it was acceptable, and there were appeals that were made. So it wasn't that draconian. And as it turned out, that initial process from President Bush's administration, the Department of Defense, headed by Secretary Rumsfeld, made its way, as you would expect, to the Supreme Court of the United States, who decided in the first trilogy of cases, Hamdi, Padilla, and Razul, that yes, you could use military commissions, but you needed congressional approval to have them. And there were certain due process rights that had to be allowed these non-U.S. citizen detainees. And that was what Congress did, and it changed the format, and we continued with the legislation and the direction of the Supreme Court.
Well, since you were a judge in a civilian court, were you ever concerned about issues concerning, for instance, habeas corpus or any of the other due process problems that people had with the military commissions?
I not much, quite frankly, because there was an issue over how much due process you allowed an enemy combatant, someone who was terrorizing our citizens. And I was very able to separate my duties as the Chief Justice of a civilian court. We heard criminal cases too, but let's call that the civilian process, and the duties of serving as an appellate judge on this court of review. And in addition, there were allowances for due process, not necessarily habeas corpus. That would come later in the Boumediene decision. And the Congress had mandated certain protocols, and there were appeals from not only the Guantanamo hearings, whether they're interlocutory or final, to us, but to the federal court system, and then by discretionary writ to the Supreme Court of the United States. And ironically, one of the complaints against the system or the administration was the lack of a speedy trial. But even if Geneva applied as to the protocol, it did apply, as the Supreme Court held in one and more of these appeals, to humane treatment of the detainees. It didn't apply to these prisoners, to these non-members of a nation that were in uniform and recognized the Geneva Accords. But even if Geneva applied as to the protocols, even under Geneva, if you capture someone in uniform, you can hold them until the end of hostilities. And so Geneva, even if Geneva applied, it didn't really make any sense. But I think there was a sense of a couple of things happening. Our psyche as Americans in the free world was that you needed a speedy trial. So I can understand that psychologically. Secondly, many of the delays were caused by the detainees themselves and their civilian counsel in appealing everything. Now, that's fine, but when you do, there's a delay. So I think you've got to take that into account. I think a lot of this too, Aaron, has to go to the fact that many of our fellow citizens and our allies, so-called, did not recognize the differences between the wars on terror and our own civilian processes and the law of war and the use of military tribunals and what that entails, as well as our own due process and procedures in the civilian courts.
Well, that is one of the issues that keeps coming up, which is whether the authorization to use military force in 2001 was actually a declaration of war, and what that actually meant, and whether it implicitly gave the president the right to, for instance, suspend the writ of habeas corpus or any other due process measures. So, could you explain some of those issues for us?
Certainly. First of all, President Bush never suspended the writ of habeas corpus like Lincoln did when the Civil War broke out in April of 1861. And then his right to suspend it, as you know, was authorized by Congress in 1863 to suspend the writ nationally. And that was really more or less to enforce the draft, the first in the nation's history. Secondly, the authorization from Congress, the authorization to use force against al-Qaeda, was passed by the Congress. And when you look at our history, how many formal declarations of war have we had? 5 or 6? This was more than in most hostile situations. So clearly, in my opinion, that statute was the authorization that the president needed, and it was passed almost unanimously by the Congress of the United States shortly after 9/11. Now, in addition, because of the legal challenges to this process of military tribunals and other parts of the war against terror, including the use of torture, so-called, and other issues relating to rendition and other issues, we had appeals that made it all the way up to the Supreme Court of the United States, like whether under Boumediene, the writ of habeas corpus applied to detainees in Guantanamo Bay. The court, I think in a 5-3 decision, said it did. So now you have more than just a single process of review. You've got the tribunal, the appeal to the convening authority, which is like the Attorney General for military tribunals, to us, to the Court of Review, then to the Court of Appeals in Washington, which is an absolute right of appeal, and to a civilian court, and then by discretionary writ to the Supreme Court of the United States. That's one line. Then under Boumediene, any detainee, and they all did, all who were left in confinement, the right to file a petition in a U.S. District Court to check their detention at the same time as this other process is in play.
Well, that raises another question. You're talking about this the checks, the venues that they have to actually appeal some of these decisions. But initially, a lot of the criticism was about presidential power and the fact that this process was essentially all in the executive branch, which was essentially what the Supreme Court decided when they had to rewrite the Military Commissions Act of 2006. Did you ever have to consider, or did you ever consider anything about presidential power when you were doing this?
You mean in the court?
Yes.
Or personally?
Well, both, personally and...
Well, in the court, no. Personally, this is where I stand on that. First of all, it was Abraham Lincoln who was defining presidential power and during Civil War. So there was already a precedent for it. And he made many acts without congressional approval, and even finally had in the prize cases the Supreme Court sustaining in a 5-4 decision his right, for example, in declaring a blockade of southern ports, which was an act of war, not decided by Congress, but by the president. And the majority ruled that when there is civil war, in this case, it just comes, and you didn't need all of the formalities of a declaration. That's just one example. FDR, Franklin Roosevelt, during World War II, signed an executive order that created a military tribunal for the German saboteurs that were landed on the east coast of the United States, and they used a military tribunal to try them and to convict them and to execute them, all but one, I think. So there was already a precedent. The administration argued that really all of the niceties of the Constitution did not evolve on these enemy combatants, so-called, at Guantanamo. But the more important thing, Aaron, to remember is, despite my own personal feelings about presidential power, which is strong, very strong, especially during a contest like this, hostilities like this, there were checks and balances at play. Appeals to the Supreme Court, appeals to Congress, decisions by the Supreme Court causing Congress to act. So all three branches were involved in this. It wasn't just the executive branch. And to President Bush's credit and his administration credit, they may not have liked it. We weren't involved in that political discourse or legislative discourse as a court of review, but they followed it. They didn't resist it in any way. Again, it was a failure to communicate, like the movie with Paul Newman, a failure to communicate, I think. And I'm not so sure that if President George W. Bush and his administration and Secretary Rumsfeld, and this was not in his character anyway, were to hire a media relations firm to get the word out about this discussion that you and I are having about checks and balances and protections and due process and writs of habeas corpus, that it would have made any difference to the American people or to those who dissented from the Bush administration, including our allies. Now, I'm not talking about rendition now or waterboarding. I'm talking about the process of trying enemy combatants.
What about the issues of waterboarding and rendition? Did you ever have to consider those when you were reviewing the cases that you did review? I
did on whether or not admissions would be admissible if there had been an experience of waterboarding. One case was involved alleged torture by the Afghanis, the administration, before turning over the detainee to the United States. Could what this prisoner revealed to the Americans be used against him because he had been allegedly tortured by the Afghan government? So that's how complicated this became. But it is clear now, in 2013, I'm no longer on the court. As you know, I left after President Obama took the oath of office, and they they created a different protocol on the selection of civilian judges that required presidential appointment and then confirmation by the United States Senate, which we didn't have during our tenure.
What about those issues of torture? Did you think they made a difference? Did you consider?
Really depended on the circumstances. Clearly, if we had conducted torture, there would have to be a hearing on whether or not it occurred, and if it had occurred, then certainly whatever was elicited from that would not be allowed in as evidence.
To kind of go back to some of the issues about presidential power, I kind of want to raise one of the other criticisms, which is about the very nature of the war on terror, whether it's actually a war or not, whether these are not matters that should be handled in criminal courts or civilian courts, as we said. And this had been the policy in the preceding decade with the First World Trade Center policy.
Sure. There was an excellent law review by in the Notre Dame Law Review about 2 years ago that I recommend to you if you have time. And this Professor Kent, who teaches at Fordham, argued, and I think convincingly, that it's the chief executive, as the commander-in-chief and chief magistrate, that can decide what kind of a forum you can try alleged terrorists, whether it's in the civil courts or in a military tribunal. I absolutely buy into that. And as precedential value, even President George W. Bush allowed some of these people to be tried or didn't argue with their being tried in civilian courts or take pleas in civilian courts as much as in military tribunals. Some of it has come down, I think, during his administration over whether they were U.S. citizens. They would be allowed to be tried in civilian courts as opposed to aliens or non-U.S. citizens in military tribunals. I don't think it makes any difference. I think under the right circumstances, you can try a U.S. citizen in a military tribunal, just as Abraham Lincoln did. And I don't think the Supreme Court decisions, which really acted as a constraint against the Bush administration, really prohibits that from happening. There's a complaint about that too, that they didn't go far enough to prohibit that kind of process or judicial process.
How is that issue decided? I'm thinking of Richard Reed, who I believe was a British national when he was arrested.
The shoe bomber.
The shoe bomber, yes.
In Chicago.
Yes.
And if he was smart enough in the creation of his terrorist instrument, he would have blown up the plane and all of the civilians riding on it.
He was tried in a criminal court, correct?
Yes.
I mean, how are those decisions made?
Well, I think they're made just like an attorney general makes them, or a district attorney makes them, as to what the charges should be, and where the forum should take place. So, did Mr. Reed actually have a trial, or did he plead?
I think he may have pled.
That's exactly. So the U.S. forum, the federal court, was a decision to be made. But I think the Justice Department, with the administration and the Department of Defense, could have transferred Mr. Reed to the military tribunal system.
Well, did that ever, give you any pause to any of the cases, thinking that they could have been tried in a
Not at all. Because I think, as Professor Michael Kent believes, that it's an executive decision. Remember, it's the president who takes that oath every 4 years on January 20th. The oath is the only one that's enumerated word for word in the Constitution of the United States, in this case, Article 2, to see that all the laws are faithfully executed, to preserve and protect the country. So just as Lincoln took that very seriously, I think every president has really taken it seriously. So they have certain prerogatives as the chief magistrate and commander-in-chief, which is another one that's loosely and not defined in the article at all, and which comes about over the exigencies of the circumstances.
So when as a nation do you decide that military tribunals and this type of military justice is no longer necessary, particularly in a war that it's very ill-defined, it's hard to define? When do we decide these issues?
When it's over. And that's been one of the biggest criticisms or comments that I get when I go around the country discussing these issues in the context of Abraham Lincoln and the Civil War. Of course, it's a quick segue from there to today's wars on terror, so-called. The same comments have been made to me, but they were also made during the Civil War. When is that going to be over? No one knew when it was going to be over. Or in World War II. No one knew when that war was going to be over. So until we destroy the threat of terror, largely, there may be, as in Israel or the West Bank or Gaza or in other areas, there may be remnants of the use of cells and individuals. I think we're going to know, and then we can change the process or get rid of the process. The Congress can do it legislatively, but because of the present makeup of Congress, I'm not sure they will do any major act of consequence during the current session here in 2013. To go full circle, Aaron, about your issue on is this a war? I say to you that and this is my opinion, not followed by some historians where I agree with them on most issues as to how they describe Abraham Lincoln and the Civil War. They do not believe this rises to the level of warfare. I invite you to check the websites and of the terrorist groups that we know exist, and to see what their mission is, which is to destroy America and us, the people and individuals here. Now, if this is not a declaration of war running one way, I don't know what is. And as I've indicated in your presence before, we lost 750,000 soldiers, North and South, during the American Civil War. If one of these cells, and they're punks really, many of them are really punks like the Boston Marathon bombers, who are enmeshed in ways of destroying our open society. And if any of them, punks or not, like 9/11, were to grab or to get hold of or create with other help a nuclear, biological, or chemical device, the 750,000 casualty rate in the American Civil War would be reduced significantly in what happens in southern Manhattan, for example. So I don't know. I just do not understand why there is this truculence to accept, not you, but a truculence to accept the fact that we are in a state of war. Is it our psyche to go about our business every day and seek material things and watch entertainment and professional football, basketball, and not even remembering 9/11 in the back of our craniums and what the threat is to our children and grandchildren and the neighbor next door? I just don't get it.
Well, you're raising really the issue of the event of 9/11 and the preceding, or the years that followed. We're talking about a major event in world history, and you were involved in part of this. And I guess I would have to ask: did you ever consider the American reputation in the world, or how the world would look upon this issue of military tribunals, or any of that?
I do all the time. And I look at it as our failure to communicate again or to spread the word on why this process is acceptable. If the international community wanted to come together in another Geneva and prepare a protocol for this kind of warfare, or terrorism or whatever you want to call it. Fine, but I don't see anyone stepping up to the bat here. Any more than I see many of our so-called allies that we created and saved after World War II and the Cold War. If you check with Sir John Keegan, the late Sir John Keegan, probably one of the best, if not the best, military historians of the age, it was the United States that ultimately won World War II because of its willingness to stick with right during the Cold War and to pour out its resources to that end. I don't see them, France, England, Italy, Germany, coming forward in helping us, at least to the extent that they should, in ending this war on terror and coming up, in our context, a viable alternative to dealing with terror and those who are captured or interrogated or tried in a military tribunal or civil jurisdiction.
How would you explain the resistance, particularly in Europe, and particularly after the bombings in 2005?
I've given that a lot of thought, and I think it's because we helped create a very liberal, and I'm not big on using labels. Governor Mario Cuomo said it's a mistake to use labels because someone could be fiscally conservative on some things and a liberal on social policy in others. But we created, and this is okay as long as there's a concomitant responsibility to this, we helped create liberal societies after World War II because of the fall of the fascists and the Nazis, the National Socialists, didn't we? We protected them, we gave them a blanket of protection, nuclear and otherwise. I served 3 years on the East-West German border, and I knew they couldn't keep freedom out of East Germany. And we are encouraging our allies, of course, for having democratic and Republican policies. And to a large extent, they have them. But there are certain rules that you have in world civilization and when you're under threat. Right now, we are under threat. And if Great Britain wants to deal with terrorists, as they have been doing, in civil courts rather than military tribunals, that's okay too, for the reasons I said. The chief executive really has the authority to say where the tribunal or what kind of a tribunal it's going to be. But, Aaron, you don't get a convicted terrorist and give him a slap on the wrist in the Old Bailey courthouse. This is serious business we're talking about. Now, whether it's evolved into a religious war of Islam against Christianity, I sometimes think that's where it's heading. In all fairness to all of the Muslims that live in the United States, I don't think that's the case here. But I'm worried about this because it's insidious and it's spreading. So when you talk about our reputation for what? For protecting us and protecting, without them knowing it or recognizing it or appreciating it, other countries, including Muslim countries?
So you see, at this point, a dozen years later, you see the war maybe even expanding at this point, of the danger expanding. So would you consider action so far successful? I mean, how will we judge that?
I think it's a mixed result. I think we've made a dent at great cost, including collateral damage of civilians who are not really the object of drone strikes, for example. But there's a long way to go. Now, how geometric this is as far as spread across the world, it's hard to define. And it may take a lot longer than we hope. And I think that includes the current commander-in-chief, who gives a speech at the National Defense University that we have to look to the end of the war on terror as if it were imminent, and I think is a great mistake because we're not there yet.
Well, I guess that raises a question I want to get your opinion on, which is you talked about drones, and now we're at the point where we don't have a detainee problem like we did because the option is to just kill them. What is this going to do to the entire judicial process when it comes to the war on terror?
Which now, the use of drones?
Yes.
Well, I think you'll have your appeals, which you have now, that you can't use a drone unilaterally against a U.S. citizen, which is current, and on a world-renowned terrorist. So that'll make its way up through the civil courts, not the military tribunals. They were created for combatants held in Guantanamo and elsewhere. But you will see ultimately a decision, I think, on the president's use of drones, or what kind of controls are needed to use this device, to use this weapon, this very effective weapon. Do I like it? No, but I mean, is it useful to prevent casualties among our armed forces or to reduce them? Absolutely. And is it useful, hopefully, to get to the end game of declaring, as we all want to do, an end in the war on terror? I think absolutely. Now, what kind of controls are mandated by Congress or the Supreme Court remain to be seen. But I think it's similar, very similar to the NSA problem or concern over wiretapping and listening in, and how broad can this be and under what control? Because the FISA courts have not been able to control the broad extent of NSA.
Okay. Well, we have a little bit of time left, so I want to switch gears a little bit. And as you know, we've here at SMU have opened the Bush Presidential Center. So I kind of want to ask about some of your personal relationship or professional relationship with President Bush or the Bush administration in and of itself. Can you tell us a little bit about that?
Well, it really occurred in two ways. One was the use of military tribunals, and I've already explained to you. One, I believe in them, or the right of the commander-in-chief to use them, or his administration, or I wouldn't have volunteered. And secondly, I've explained the appointment process and working with the Department of Defense, first as a judge, a civilian judge, and then as the chief judge after Attorney General Griffin Bell died of cancer, and then my departure once President Obama was inaugurated. So I've discussed that with you. I really met with people in that Department of Defense category, including the Secretary of Defense and General Counsel, without any direct involvement with President George W. Bush. But the second, more direct involvement was the creation of the Abraham Lincoln Bicentennial Commission, on which I served, and which was created by Congress to commemorate the 200th anniversary of Abraham Lincoln's birth in 2009. It was created many years before. I was appointed to that commission, served on it, and President and Mrs. Bush had at least two receptions at the White House where commission and advisory committee members were invited. So we met President Bush and Mrs. Bush, and he himself is a great admirer of Abraham Lincoln and has told me, and it's been publicly noted, that during tough times, and every president does this, they have to get right with Lincoln. He read at least 11 books or biographies on Abraham Lincoln. And why is that? Because Lincoln is the standard bearer for presidential power, for dealing with great challenges, for his empathy and compassion, and his ability to exercise wonderful judgment, certainly making mistakes because we're all human, and Lincoln was human and made mistakes too. So that was the context in which we matriculated with the president and his first lady.
Okay. Well, before we close, are there any issues you want to talk about?
Well, no, I think we pretty much covered the waterfront. I'm pretty strong in my views, as you can tell, Aaron. But I have not been dissuaded, despite using a judge's look-see and balancing on what is the direction to go. There are options out there, and I will say to you, and I think you know this from knowing me, that my personal views, or my views on the use of military tribunals, never has colored being fair and impartial to when issues would come up from detainees in Guantanamo Bay. Despite my strong views on the use of the process, does not mean that necessarily that it's going to be used against a non-U.S. citizen or a U.S. citizen charged with terrorist acts or providing material support to terrorists. And I believe and know that all of the other judges, whether military or civilian, on this panel, through these renditions of dealing with this problem, feel the same way and bent over backwards to be fair and impartial in dealing with these issues.
Thank you very much.